Good afternoon. We're going to start. As you know, the politics of side events, it obliges us to start very fast and leave the room very fast. So we're gonna get ahead with our event. Excellencies, distinguished panelists, colleagues and friends, and those following us online, welcome. Welcome to the side event, to the 61st session of the Human Rights Council, titled "Tackling the Protection Gap: Host State Responsibility to Prevent and Respond to Transnational Repression," which also for the ease of time, we're going to be referring to as TNR. This event is co-sponsored by Human Rights Watch, Human Rights House Foundation, the International Federation of Human Rights, FIDH, and OMCT, both within the framework of the Observatory for the Protection of Human Rights Defenders, as well as by my own organization, the International Service for Human Rights, ISHR. I'd like to recognize the support of the Tackling TNR Europe Working Group, which ISHR, Human Rights Watch, FIDH, and Human Rights House Foundation are part of. And I would also like to express our gratitude to the Permanent Mission of Germany for their financial support to this event. My name is Rafael Viana David. I am Program Manager at ISHR, and I will be moderating today's discussion. Just before I get a little bit more background to this event and introduce our panelists, I would like to clarify a few logistical points, in particular because we have a really full room today, and that's of course very exciting. This event is being live streamed on YouTube at ISHR Global, and a replay of the event will be available on our channel. To ensure that the live stream works well, I just wanted to remind our panelists and all those speaking from the floor during the Q&A to make sure that you mute your mic after your interventions, just so the camera works well. Please note that my ISHR colleague, Francisco Perez, who is just at the back there with the camera, is the only person that is authorized to take pictures, so please do not take pictures out. He's the only person that can do this, and if you'd not like to be photographed, please indicate it to him. And lastly, but importantly, in particular, given the relevance of this event, I'd like to remind you of our zero tolerance policy for any instance of intimidation or reprisals against any of our speakers or those in the room. We're joined today by four fantastic panelists that I also had the pleasure to be working with throughout these years. Starting from my right, Saeed Al-Wadai, who is Director of Advocacy at the Bahrain Institute for Rights and Democracy, and who will, of course, bring a vital perspective of human rights defenders. Right next, we have Professor Ben Soul, who is the UN Special Rapporteur on the promotion and protection of human rights while countering terrorism. Right next to him also, Professor Hélène Tigroudja, who is the Vice Chair of the Human Rights Committee. And last but not least, our dear Beuret, who is the coordinator of the Civic Space Unit at the Office of the High Commissioner for Human Rights. Thank you so much for joining us today. This discussion will take the form of 2 rounds of questions to be followed by a Q&A. And of course, as you know, the main reason why we're gathering these rooms today is because we know that TNR is no longer an anomaly. It is a rising global crisis. Those of you that, of course, follow the Human Rights Council, you will know that this discussion has arrived very strong at the Human Rights Council, in particular because states and their proxies are increasingly crossing borders to silence dissent and target individuals and communities on the territory of other states through direct or indirect channels, and through tactics that we now start to understand a little bit more, ranging from digital surveillance, renditions, misuse of Interpol notices to legal harassment, and the targeting of family members. This phenomenon is global in scope, with both victims and perpetrators across all regions, all continents. And while human rights defenders remain key targets, journalists, academics, and entire diaspora communities are now in the crosshairs. 2025 has seen a surge in awareness marked by a joint statement delivered by Germany on behalf of a cross-regional group of more than 45 states at the last council session in September. And while a range of governments have adopted initial measures and policies to address TNR, TNR has also been increasingly recognized and discussed by parliaments across the world, most recently through a dedicated study and resolution of the Parliament of the EU, and an inquiry by the UK Parliament's Joint Committee on Human Rights. UN human rights bodies, of course, have not lagged behind. On the contrary, they have increasingly documented and recognized TNR, particularly with the ISHR's first brief on TNR, which I'm sure that Birgit will talk more about, but also through a growing number of references to TNR in special procedures letters and reports, in treaty body concluding observations, in agency resolutions on human rights defenders and the safety of journalists, and most recently in the Secretary General's reprisals report as a form of reprisal for cooperation with the United Nations. But awareness alone does not equal protection, as we know well. A comparative report prepared last December by Oxford Pro Bono Publico for ISHR shows that the UN and regional human rights systems are increasingly recognizing and naming TNR, but points to common protection gaps across all systems, including unclear responsibilities of states hosting exiled HRDs to protect them from third-party states, including regarding their positive obligations to prevent acts of TNR. And this is why today we're trying to move from recognizing the problem, the forms that it takes, and the impact that it has on communities, to discuss and identify solutions in line with international human rights law. And for this, today's event will seek to clarify these positive obligations of states to prevent and respond to TNR against individuals and communities on their soil, discuss ways in which international standards could be strengthened, and identify in particular critical gaps in the implementation of such standards, what we usually call the protection gap, and which national institutions are responsible for this at the national level. So without further ado, I would like to kick off our discussion by passing it on to my colleague, Hélène Tigoja, Vice Chair of the Human Rights Committee. And my first question to you, Hélène, based on the Human Rights Committee's most recent practice, could you clarify what is the legal basis of states' obligations to prevent and address TNR under the ICCPR, and relatedly, which rights are protected under the Covenant? And let me just add one question there. Are there specific areas that you feel that international standards could still strengthen and clarify those obligations? Thank you.
Thank you, Raphael, for the invitation and for organizing this very important event, because as you said, I mean, the Human Rights Committee, so it's the monitoring body of the International Covenant on Civil and Political Rights, and we are receiving more and more information on the use of transnational repression. So I think for the committee, the Human Rights Committee, it's really a growing concern, and I will give some concrete example a bit later in our conversation. So first about the legal basis and the way the Human Rights Committee approaches this question of transnational repression. It's true that for the Human Rights Committee, based on the Covenant, there are many, many rights that are at stake and that are violated or potentially at risk when we talk about transnational repression. Of course, the right to life, Article 6. And I remind that Article 6, it's a non-derogable right, so under no circumstances states could restrict or limit the right to life. So it's a right to life question, but it's also a prohibition of torture and ill treatment question. So Article 7 of the Covenant. But as you know, when we talk about transnational repression, we most of the time also talk about arbitrary arrest, arbitrary detention. So it's also, states have also obligation, negative and positive obligation, as you said, based on the prohibition of arbitrary detention, arbitrary arrest, and I will go back a little bit later to this element. Of course, it's also a question for the Human Rights Committee of access to justice or lack of access to justice, so Article 14 of the Covenant. It might also be an issue or a problem of the right to legal personality, Article 16 of the Covenant on Civil and Political Rights. And of course, I'm sure colleagues will talk about civic space and the threat on civic space. For the Human Rights Committee, it has also to do with freedom of expression, freedom of religion, because there might be also example of transnational repression for religious grounds, and it has to do also with the right to privacy. And very interestingly, I'm not going to dig into the counterterrorism element, but what the committee is seeing more and more is the misuse of the fight against terrorism narrative or fight against extremism. And of course, for the Human Rights Committee, the word extremism is extremely broad. So we are always very concerned when states bring this ground for restricting the liberty of someone or arresting someone based on the need to fight against terrorism or national security or extremism and so on and so forth. So that's, I would say, the legal basis, very briefly drawn, the legal basis of states' negative and positive obligation. Now you also asked about what are the gaps or what are the questions that are not necessarily, that are overlooked. And one of the main questions, I would say, is the combination between human rights obligation and international judicial cooperation. Because as you rightly said, what we also see in transnational repression movement or phenomenon is the misuse of judicial cooperation tools. You mentioned the Red Notice, Interpol. So we should also actually engage the conversation with Interpol, with bodies like Interpol. And sometimes it's not easy for states to make the balance between their human rights obligation and their international judicial cooperation between other states, and that's where the positive obligation, I would say, lies. So maybe I can stop there for now. Thank you.
Thank you so much. And indeed, I didn't want to nudge the question, but I'm happy that you raised that last point. And that you gave an introduction now to Ben, of course. So very simply, Ben, how does counterterrorism law pose distinctive risks for TNR?
Thanks. Thanks so much, Raf. Good afternoon, everyone. And my thanks to the organizers for putting on this very important event today. Look, in the experience of my mandate as Special Rapporteur on Human Rights and Counterterrorism, I'm concerned that international obligations to counterterrorism have been abused by too many states to legitimize distinctive types of transnational repression. Now, of course, wholly extra legal forms of transnational repression are also committed in the name of counterterrorism, including violence, threats of violence, cross-border abductions, enforced disappearances, and online harassment and stigmatizing political labeling. But the twisting of counterterrorism law seeks to perversely legalize other practices, and the global fight against terrorism, led by the Security Council, generates unique pressures on other states to cooperate. So I want to suggest 5 trends that I've been seeing in my almost 3 years in this job. Firstly, the abusive listing of individuals or groups as terrorist or extremist, typically without due process or judicial safeguards and based on overbroad definitions of terrorism, has had many cross-border human rights impacts. It results in freezing of assets often, which interferes in rights to property, the home, work, and an adequate standard of living and family life. Travel bans and watch lists interfere in freedom of movement domestically and internationally. Banning organizations interferes in freedoms of expression and the media, association, assembly, political participation, and minority cultural or religious rights. Other countries often feel political pressure to recognize and implement foreign terrorist lists. Listing can also result in banks and humanitarian actors de-risking, cutting off funds for vital human rights work. It further stigmatizes individuals and impacts their right to reputation. Secondly, we've witnessed abusive requests to extradite individuals based on false allegations of terrorism. The abolition of the political offence exception to extradition for terrorism offences has increased pressure to extradite, despite the absence of a common international definition of terrorism. Extradition requests can compromise human rights where the host state lacks robust safeguards against refoulement to arbitrary deprivation of life, torture, ill treatment, persecution, denial of justice, or arbitrary detentions. Some requests are driven by the rights-deficient criminal cooperation procedures of regional organisations, like the Arab Interior Ministers' Council arrest warrants for terrorist suspects, and sometimes even Interpol. Thirdly, there have been attempts to forcibly repatriate refugees or asylum seekers in order to circumvent extradition law. Threats against family members is another tactic used by some states to coerce refugees to return home. False accusations of terrorism are used to manipulate exceptions to the Refugee Convention definition and the exceptions to non-refoulement, or to add exceptions not found in refugee law. Even wartime powers lately are being invoked to override protections against refoulement. Fourthly, the misuse of new surveillance technologies to counter terrorism has enabled the targeting of human rights defenders, including spyware, facial recognition, border security tools for sharing passenger information, and lately artificial intelligence. The development and export of such technologies has often not been subject to prior human rights due diligence assessments. Their application has not been adequately regulated, including regarding authorization of use, privacy, and personal data protection, and oversight, accountability, and remedies is often lacking. the collapse in a responsible online content moderation by big tech companies in recent years has turbocharged online harassment. Malicious use of artificial intelligence is enabling predictive profiling and mass surveillance of exile communities, identifying new targets for transnational repression. Finally, while many states have strong legal safeguards in the context of formal extradition, mutual assistance and refugee law processes, they often lack comparable protections in relation to executive cross-border information sharing, including between police, security agencies, financial intelligence units, border authorities and militaries. Safeguards for privacy and data protection are often lowest in counterterrorism cross-border contexts, despite the high stakes. Information sharing can identify targets of transnational repression, including for arbitrary arrest or worse. Thank you.
Thank you. Thank you so much, Ben, for laying all this out so clearly and building on the last point, actually, that Ellen did about judicial cooperation. I'll turn now to Beuret. Beuret, in June last year, I think most of us in the room are aware that the ISHR launched an excellent brief on TNR, quoting the Special Rapporteur on Freedom of Expression, who affirmed that there's no international legal gap, but there's a dangerous protection gap, hence, again, the title of this event. Based on this brief, what are these gaps and what can host states do to strengthen effective protection?
Yes, thank you very much. I'm very happy to see so much interest in this issue. That is, you know, I always, when I think about TNR, it really, we should never forget that what it means is that the people who are concerned by it really have nowhere to turn. So it must be at the center of what we try to address from a human rights point of view at the international level. So I think it's very timely and good that we are having the discussion and that we are also trying to drill down a little bit. In terms of the key gaps of protection, I think we've heard already some of it now in what Ben said. Really, one of the key gaps is our legal, criminal, administrative frameworks, diplomatic maybe, are not equipped to deal with the phenomenon. Yeah, they react to other. They are set up to respond to human rights violations, to international crimes. But as we've just heard, many of the things that happen are really in gray zones. And I think having the conversation about what needs to happen so we adapt them more to the new challenges is really key. And then. I think, you know, that idea also really applies to online surveillance. We see a bit disjointed efforts to address those issues, and it would be very timely and useful and really a good topic also, I think, for the Geneva community to really drill a little bit deeper and find ways to bring the more security experts also to the table. And then, of course, we also always struggle with the family side of things. Yeah, how do we make the link? I mean, our law is just not the best tool to do that. So we really need a clearer framework, and then also really, I think, need to think through who needs to be involved in building that framework. And of course, that goes back to what we've heard, building awareness of what it means. And that is complicated because it means really understanding many contexts. But needless to say, of course, the UN human rights mechanisms and the office is well placed to help with that, because many of the findings and so on that we've issued over years are very relevant to the space. The second challenge I just want to mention briefly is the fragmentation of the protection landscape. I think we see very much that, you know, the protection efforts often happen around specific communities or specific issues, and there is not enough connection between them. And this idea that, you know, of course, a protection mechanism needs to be able to respond to the specific needs of women or, you know, young people or journalists. but at the same time, we really don't do ourselves a favor if we have different protection mechanisms for each of those communities. We will just lose out in terms of its effectiveness. Yeah, and I think beyond what I just said, really thinking of, convening across these silos, as we often call them, and focus on how can a joint response really look is very important. For example, also bring in the ILO, because we see some of those things in the trade union space, and as I already mentioned, the journalists. And of course, maybe just one sentence, that the office has the unit has created a community of practice exactly to address some of these issues, because we think the UN is well placed to work a bit across these themes and challenges. And maybe the last point, I don't know whether I'm already long. I think we still face a bit an issue with the fact that people understand protection often as a moment, not as a process. And we need to think again what protection really means. Of course, there is a moment when people have to hide or run or whatever, but really, that's only at the end of already a long process, and often the beginning of a long process. So I think if we can manage somehow to make that shift to really thinking about protection as something that goes on much longer, and that to address TNR, we really need to think differently about protection more broadly, and then many of the issues we are hearing about will actually we will be able to address them more effectively.
Thank you. Thank you so much, Birgit. I'll now pass it on just to my right to Said. Said, in particular, to build a little bit on your experience as a Bahraini, you faced TNR in the UK. Can you tell us a little bit more about the ways in which the government has carried out TNR and the ways in which the local authorities have addressed it?
Thank you so much. Really glad to be here. And honestly, I spent last night just thinking about what is happening in our region. It was very tough to see a missile is launched in Bahrain, and it was devastating just to see the horror and the fear that people witness, and what would be the consequences of this illegitimate war that should not happen. And we don't know how it's going to end and what would be the casualties. I'm here today just to speak about my own experience, which I believe it was a very strong case of TNR. And I begin to understand actions I take in London would have direct implication to my own family in Bahrain. It is extremely hard to understand it until you are hit with that reality. 27th of October 2016, I took part in a protest against the King of Bahrain as he was about to meet with the British Prime Minister. All we did is we were waiting for his motor vehicle to enter the 10 Downing Street, took part in a protest, and that we thought, I took myself and tried to stop the car entering the 10 Downing Street. Obviously, the police stopped. It was all fine, nothing to be worried about. I was stopped for a few minutes by the police before I was let go. On the same day, a few hours later, my wife and my infant son were about to leave Bahrain to come to London. They were there on a holiday, and there the authorities took my wife on a side, begin to just inspect her, and then took her into a room where she was dragged in the duty-free. She didn't know what's going on, and they were very, very hostile towards her. She was with 18 months old child, and she was just terrorized. For 7 hours, she was interrogated, and she was told, we're gonna bring the animal, your husband, and where would you like us to start, with your family or his family? And it was almost like a nightmare. I meant to pick them up from the airport, all I saw, it was my family didn't know about it until my wife herself called them and told them about what happened. They came to pick her up, and then I think what we begin to understand later was so severe damage on her that she was frightened if she say anything that there would be further implication. I think we took the decision to say we probably will not see her again if I did not speak out about what she has experienced. For this, Human Rights Watch interviewed my wife, and there was media interest with a headline in the Sunday Times stating Bahrain terrorizes refugees' family. Questions, the attention was still on the country to answer the questions. Why did you abuse this family, and would you let them out, and so on? I think the media played a significant role in getting the attention this case deserves, and then later Bahrain allowed them to return back. But it was March 2017, a few months later, and I was attending the Human Rights Council session where I figured out that it was this time my wife calling me to say they came after my family, they arrested my mother and my brother. And it was during the very same regular Human Rights Council session. So the message was very devastating and clear. If you're going to continue to expose human rights violations in Bahrain, we're going to take a hit on your family. And, you know, the family did suffer quite a lot before they were released in 2024. The impacts of the actions the country took were profoundly devastating. I mean, one of them is one action Bahrain took in 2015 is they resorted to revoke my citizenship, rendering me a stateless. It's a blatant breach to international law, but it took a state to stand up and to say this is wrong. The impact wasn't just on me. Then later when I had a child, my daughter, my second child was born as a stateless child. As a consequence, as implication of this decision, because especially when you are married to a Bahraini woman and the law is discriminate against women, cannot pass their citizenship to their children, then the child will be in legal limbo without even without a nationality. And the last and the final is the action of surveillance. 2021, when I was approached by the Guardian, a newspaper, to say, look, we saw your mobile number among a list of many thousands, there were over 50,000, and if your name is listed there, it means you've been hacked with the Pegasus Israeli software, which obviously, despite that there was a lot of reporting about what happened there and so on, the UK government did not do much about it, but rather it took a legal action for dissidents in the country to bring it before the UK jurisdiction. And now the case is overseen by the Supreme Court, and whatever outcome would have massive implications about the misuse of surveillance. Thank you very much.
Thank you so much, Said, first for reminding us of the cost of you being here, and you having done this for so long now. So thank you so much for agreeing to speak and share this. I think, you outlined kind of like a whole spectrum of TNR, from the breadth of, from the misuse of spyware to, the targeting of family members in country to reach someone that is outside. So really the kind of like this national, this transnational aspect of it. So my second question back to you is based on this and on the different aspects of TNR, what are the concrete measures that you think that states, including the UK, but maybe also others, could adopt and should adopt to prevent and suppress those forms of TNR?
Thank you. That is extremely important question, because when it comes into response by states, I think the first one is there got to be a recognition, acknowledgement that this incident happened, and try to understand what has led to it. Once this is well established, clarified, then the states should begin to express concern publicly, and also engage with those authorities and make it clear that this is not going to be tolerated. I think I was lucky to be in Britain, where there is interest within the media. Parliamentarians were bringing the cases before ministers and so on. But I do think it just has to start with acknowledging what went wrong and start raising public concern about it. Without it, the states would feel only more emboldened to escalate and to take further steps. Thank you.
Thank you. Said, now back to you, Ben, and building a little bit on what you were sharing before. How can states legally and effectively prevent and suppress CNR in the context that you know well, which is that of counterterrorism abuses?
Thanks, Raf. I have 5 suggestions to combat the trends I mentioned earlier. Firstly, states should not automatically recognize foreign terrorist listings or give undue deference to them, particularly in the absence of access to the source information on which the listing is based. My report on administrative measures to the General Assembly last year sets out best practice international standards on the grounds and procedures for terrorist listings. And unfortunately, the laws in too many states do not meet those minimum standards. To prevent transnational repression, states should persuade and pressure other states to ensure that their terrorism definitions, laws, and listings comply with international law. Secondly, extradition and mutual assistance requests must likewise be subjected to rigorous scrutiny of foreign terrorism charges. The risks are heightened where the requested state does not require evidence of a prima facie case and instead follows the less protective rule of non-inquiry approach into the foreign evidence. The United Nations Model Treaty on Extradition suggests that states could mandatorily refuse extradition, quote, if there is insufficient proof, according to the evidentiary standards of the requested state. Even where courts do not scrutinise the evidence, executive authorities usually still have the final say over extradition and should act as a human rights backstop. Non-discrimination, fair trial and non-refoulement safeguards should also be legislated and applied in the extradition context. Thirdly, states should carefully scrutinise any claims that asylum seekers and refugees are terrorists who fall foul of the Refugee Convention exclusion clauses, the exception to non-refoulement or the expulsion clause under the Refugee Convention. Overexpansive interpretations in countering terrorism must be avoided. The full scope of non-refoulement under human rights law must also be applied even if the person is outside refugee protection, including in relation to risks of arbitrary deprivation of life, torture, enforced disappearance, arbitrary detention, flagrant unfair trial, and other serious human rights risks. Fourthly, states must ensure adequate regulation of new technologies that are deployed to counter terrorism, including prohibitions on the use or transfer of technologies that cannot be used in compliance with human rights or which pose unacceptable risks. They must effectively regulate corporate actors and not leave it to a laissez-faire self-regulation model, including through requiring human rights due diligence and online moderation to ensure digital safety. And I commend to you my position paper on artificial intelligence, human rights and counterterrorism of December last year. Fifthly, states must strengthen and formalise safeguards on cross-border information sharing by all authorities, including in relation to human rights due diligence, privacy and data protection, and ensure effective independent oversight and accountability. Transnational repression in counterterrorism context also requires a host of other effective measures by like-minded states, which are also vital in preventing transnational repression generally. Firstly, sharing intelligence to prevent transnational repression and cooperating in criminal investigations by other states to suppress it. Secondly, coordinating to impose Magnitsky-style sanctions on individual foreign officials allegedly responsible for violating rights as lawful countermeasures under international law, and even applying, as some states have, state terrorism sanctions in the case of lethal threats to life. And in my latest report to the Human Rights Council, to be launched tomorrow, I have a whole section on state terrorism and how you can think about issues of state-sponsored terrorism. Thirdly, publicly supporting other states who denounce transnational repression and not appeasing powerful states. And for example, when Canada called out attacks on the Sikh community in Canada, unfortunately, not too many other states came to support Canada in calling that out. Fourthly, increasing practical security advice and protection for victims and their families. And finally, and this is specific to counterterrorism, the United Nations counterterrorism bodies in New York and the Security Council should be much more assertive in condemning transnational repression where it occurs in the name of counterterrorism, including in the implementation of Security Council resolutions and sanctions. Only by relentlessly raising the price of transnational repression can we hope to effectively reduce it. Thank you.
Thank you again for laying out 5 steps for 5 initial concerns. That's great. I'll pass it on now back to Hélène. Hélène, on the basis of the recent reviews that the committee has engaged on, could you provide a couple of recommendations, also drawing from perhaps concluding observations for concrete measures that states can take to adopt to fulfill their covenant obligations in relation to TNR, in particular host states?
Yeah, thank you. Thank you very much. First, I would like to stress the fact that for the Human Rights Committee, this question of transnational repression actually is not that new, because our very first decisions at the beginning of the 80s were about the transnational repression. But of course, we didn't frame. I mean, the Human Rights Committee didn't use this vocabulary, but it was about enforced disappearances or extrajudicial killings. In many Latin American countries, based on this collaboration of state and transnational repression, that they are quite strong judgments of the Inter-American Court of Human Rights on this question and states' obligation as framed also by Ben. But of course, conceptually, now we are receiving more and more information on what is framed as a transnational repression. So now we are trying also to identify more the different element of what is transnational repression. So that was the first point I wanted to stress. The other element, and I really appreciated also your testimony, is that it's true that we are receiving information that sometimes does not make very visible the transnational repression element, as you say, revocation of citizenship or non-renewal of passport. And these are tools very efficient, unfortunately, because as you explained, I mean, without a citizenship, without a passport, it's a sort of legal death because you cannot do anything. So that's why also I mentioned the right to legal personality. That is really something less visible, I would say less spectacular than an abduction or enforced disappearance, but actually that has indeed, as you rightly explained, a very, very severe impact on people. So now it's true that we are receiving more information, it's more visible, and I will give you 3 very recent examples where the Human Rights Committee precisely used this vocabulary of transnational repression and framed indeed some concerns, but also some recommendation. So in 2024, we had 2 state parties review, one with India, the other one with Turkey, where actually the Human Rights Committee adopted, I would say, quite very strong language on the concerns we, based on the information we received, both in India and Turkey, about transnational repression against political opponents, against journalists, against media workers, and for Turkey, people affiliated to the Gulen movement. And another element that was of concern for the Human Rights Committee was precisely what I mentioned earlier, the misuse of red notice, Interpol red notice. And again, I mean, using also this counterterrorism element or national security or the need to fight against extremism. So it's really something, it was one of the first time the Human Rights Committee used this element. and also abduction, especially in the concluded observation for Turkey. The Human Rights Committee expressed really concerns about information on abduction, extraterritorial and forced disappearances. This is another very strong concern the Human Rights Committee has. More recently, last year, the Human Rights Committee had the review of Vietnam 2025. So the concluded observations are published, of course, on the website of the Human Rights Committee. And here again, the Human Rights Committee expressed its concern about transnational repression in relation to enforced disappearances and enforced disappearances of, human rights defender, journalists, political opponent, and so on. And interestingly, it was the first time the Human Rights Committee made the connection between Vietnam and the neighbor countries and clarified a little bit more the state's obligation and positive obligation, especially of state when they are requested an extradition or to participate to removal from territory. And again, in the Vietnam concluded observation, the Human Rights Committee insisted on the need to be very, very careful about arrest warrant of political opponents, journalists, human rights defenders, social media, trade union leaders, indigenous leaders, climate change people, and so on and so forth. But also the need to be very careful with Interpol tools. So these are the most recent example, I would say. Thank you.
Thank you so much, and the panel has done a great job at sticking to the time, so I really appreciate that. It's never an easy job for the moderator. Last but not least, Beuret. So we've heard extensively about protection, in particular against physical forms of TNR, but Said outlined digital surveillance. The use of Pegasus, I think, was an important subject of discussion. So I wanted to ask a little bit more, building on the ISHR TNR brief, if you could build on that and share a little bit more concrete measures that you think states could adopt.
Yes, so again, I really see 3 gaps. I'm sure there are many more, but that's what I would like to put on the table now. One of them is really the fact that it's very hard to come by evidence of some of the digital transnational repression, because of course, especially when it comes to surveillance or to sophisticated attacks, the human rights community does not necessarily have the tools and the resources to dig into this. So I think finding ways to strengthen monitoring, and I know there are efforts in that direction, and the reporting, the specific reporting also about cases in that area are very important. And of course, I think someone has already mentioned human rights due diligence, and like really doing meaningful human rights due diligence. Not only companies, also states will actually really help to understand what the risks are that arise from new technologies. And just to say that, of course, with the increased use of AI, we really will, I think we can, we need to be ready for more of this. I think, you know, the biometric possibilities, all of those things will make it probably even harder also to understand where some of the data comes from and so on. The second point I wanted to make, and I'll make it very briefly because we've heard extensively about the use of counterterrorism frameworks. Of course, it's not only counterterrorism, and one of the things that we've been involved on as an office quite a bit is looking at the cybercrime convention that the UN has adopted, which actually also opens some doors to international cooperation and in the area. So I think, you know, really, and I think I've said it already, bridging the two communities and understanding a little bit better how we make the security people more aware of the risks is absolutely urgent. And then maybe just to say, of course, yes, Interpol is one of the players that we can work with, and it's again up to member states to strengthen Interpol in a way that that they can actually also make the judgment in terms of what are red notices that are valid and others that are not. And then just maybe again, it's a bit like my first intervention. I think really we need to understand, we need broader measures to strengthen protection. We really need to think about the extreme funding cuts. Yeah, we are not seeing so much the consequences yet, maybe, but many of the small NGOs in very complicated contexts do not have money to think about security anymore. The networks that helped them in the past have seen cuts. So one of the points I always like to make is we need to become much better to really react at the threat stage. So not wait until the whole protection case has already built. Understand a little bit earlier how we can react. And then I think most of the, I mean, maybe the last point is really, we as an office also work with ITU and others on embedding, for example, encryption or privacy tools in technical standards. So in the standards that the technicians are asked to develop to guide design and deployment, and I think that is also a promising area of work that we can pursue. Of course, we have a new player in the field, which is the private companies, and I think we also need to find ways to engage with them and maybe center much more protection. Of course, let me just mention that we have a mandate, or the Human Rights Defenders Resolution mandates us to write a report about human rights defenders in the digital age. And of course, these are some of the questions we will also look at in that context. Thank you.
Thank you so much, Birgit. We have 8 minutes for Q&A, which is average for a Human Rights Council side event. So I'd ask if there's any questions or interventions from the floor, and to really keep it brief, please. And if you could just raise your hand, I'll take maybe 3 interventions. If you could say your name and affiliation. Sir on the left, please, first.
Yes, thank you. My name is Mohammed Serkal. I'm the director for Solidarity Advocacy Group, and it's very concerning, the TNR and the trend of TNR, but we focus on the physical repression, but as Said Awadi said, as digital repression that we face as a human rights advocates. And the worrying is we are facing this repression in Europe, where we expect it to be, protected and free to express ourselves. Last time I had a conversation with someone in Germany about, I was expressing the issue of the children being attacked on the wall. He said, please don't talk to me in WhatsApp. Use some other apps that you can talk to me. So I think a suggestion, or by the UN or by the UN committee here, is how we can develop an app where a human rights activist can use to be protected and to be also to prevent any attacks on them online. And this is really worrying. I mean, we already have limited spaces to talk, and we comes online, and that we could be more oppressed. So this is my suggestion, if we can develop an app to protect the human rights activists online. Thank you.
Thank you very much. I see one question here, and then gentleman in the back.
It's Andrew Chubb from Lancaster University. I would like to invite any of the panelists to comment on any potential host state obligations under ICCPR Article 2, obligations to respect and to ensure within the territory, to all individuals within the territory, the rights recognised in the covenant. And relatedly, any particular host state obligations on host states that host international organisations, such as the country that we're in right here.
Thank you. And the gentleman in the... okay, 2 questions, and that's it, if you can keep it very brief. So maybe the gentleman on the right and then on the left. Thank you.
Yeah, Sharaf Aziz, Justice for All International. My question regarding the unfettered powers given to the President of the United States through emergency law of United States. last year before, when the United States was under review by the Human Rights Committee, we submitted an extensive report concerning non-compliance with Article 4. And unfortunately, Human Rights Committee skipped Article 4 in its concluding observations when it comes to United States. If you could comment how Human Rights Committee could be now instrumental, or maybe to follow up on this issue and address this issue with the United States. Thank you.
Thank you. And maybe 30 seconds, the gentleman on the left. Yes.
Thank you. Thank you. My question was to Madame Ellen. When your speech is talk about the rights of justice access. My question is, how can the rights of access to justice be effectively granted for victims of human rights violations in refugees camps when the host country has delegates its administration and the management of these camps to a non-state armed group? So what mechanism exists to ensure accountability and legal remands for victims under such circumstances? Thank you, Madam Ellen.
Thank you. So we have just a few minutes. Maybe I think a lot of questions were regarding the Human Rights Committee, so I'll pass it to you, Ellen, and then if anyone, maybe 1-2 minutes, and then I'll just see if anyone else has concluding remarks, maybe 30 seconds. Thank you.
Okay, 1-2 minutes, but these are tricky questions. So now, I mean, thank you very much for your question. So first question, the question about Article 2 and how to use the respect and ensure element we have in the committee. It's something the Human Rights Committee is working on, especially as some of you know, the Human Rights Committee is drafting a new General Comment 38 on freedom of association. And so far we have a couple of paragraphs precisely clarifying also the due diligence element and what it means for all states involved in transnational repression, this respect and ensure, including when private actors are involved. So be patient. I hope in a couple of weeks we will be able to clarify. Then the second question about non-compliance with Article 4 of the Covenant and how to engage with states like the US, especially on this question. I have to say that on this, and it's not only the Human Rights Committee, but it's very difficult because we cannot ask a state to derogate, you know, from its obligations. So it's really a decision of the state to decide to notify the derogation element. And in general, I have to say that human rights bodies, I would say, are very passive on this. It's really a decision of the state to use this mechanism of derogation. And if the state decide not to derogate, I mean, not to send the notification, there's not much the Human Rights Committee or even other human rights organs would do. And I remember your predecessor as a special rapporteur published an excellent report on de facto or de jure derogation from human rights obligations. So here we are more in a de facto derogation from human rights. So there's really limits, I have to admit. And third question, access to justice, especially in refugee camp, when non-state actors are involved. Again, I have to admit that so far, the Human Rights Committee does not have a lot of practice or jurisprudence in terms of clarification of states' obligation, precisely because, and I go back to the very first question, we do not have a lot on what it means to, in terms of positive obligation, to respect and ensure. But again, as you said, it's really something that is really growingly visible. And I hope we will also be able to address and to provide more clarification because it's a growing concern. So thank you for the question.
Thank you. I'll have to use my moderator executive decision to close this event, but I definitely invite everyone to continue the conversation outside. But thank you so much for our panelists and those following us online. We hope to keep everyone engaged on this issue throughout the year. And perhaps just to finish with a kind note to ask to kindly leave the room. Well, stay for the next event, of course, but if you're unable to, please kindly leave the room fast to ensure a smooth transition. Thank you so much.
Thank you. It was close conference.